Edith Blakeney on behalf of Mr. Pierce, Your Honor. Right now, my client does agree to participate virtually. My client would like to represent himself on this. Sir, can you state your name for the record?
David Pears.
I can't talk to you if I can't see you, Mr. Pears. Okay. All right. So, Mr. Pears, you understand that you're being charged with resisting arrest? Is that your understanding?
It's just resisting. That's it. Just resisting.
Resisting and obstructing arrest. Yes. That's what you're charged with.
Okay.
What did you think you were charged with?
It was either just resisting or just obstruction or both. I wasn't sure.
Well, it means it's either or. I mean, I don't know what happened. So it could be resisting, it could be obstructing, but it's
interchangeable.
It's sort of interchangeable. You understand?
This is how some court cases quietly spiral. Not with shouting, not with drama, but with confusion. Within the first minute, the defendant isn't even sure what he's charged with. And that matters, because if you don't understand the accusation, you can't defend yourself against it.
Okay, and how are you going to do that? Are we having a jury trial?
I just wanted to speak my perspective on what happened and basically get the case dismissed. I didn't do anything wrong. I'm 100% innocent.
Well, you can't just talk. I have to have sworn testimony. I have to hear the testimony of the police officer. I have to hear, you have to have the opportunity to testify or not testify. And if you're telling me you want to testify, you need to understand that you're giving up your right to remain silent, that there's no obligation for you to say anything. The burden is on the prosecutor to prove that you are guilty. It's not your obligation to prove innocent. You have to understand how to put in evidence. You can't just speak. You have to put in the appropriate evidence under oath. And, there might be a technical aspect to this that you may end up sabotaging yourself because you don't know the rules. But if you want to do yourself, you certainly have the right.
So if I represent myself, you saying I can't speak for myself on trial? Or is it?
Yeah, you can, but you're not just going to come in here and speak. The prosecutor is going to bring in the police officer. The police officer is going to testify. You're going to have to question or cross-examine them. There's all kinds of things that go on. There's certain things you can talk about. There's certain things you can't talk about. I don't know what happened. I don't know if there are certain things you want to tell me that you're not allowed to tell me under the rules of evidence. I mean, the fact that you don't understand what I'm saying is part of the problem, is that you don't have the training to represent yourself. But first of all,
listen to how patient the judge is here. She's not attacking him. She's warning him. Court isn't a place where you just explain your side. There are rules, evidence standards, and traps you don't see until it's too late. And the scary part? The judge already sees where this could go wrong.
I'm pleading not guilty, so and I just want to have a chance to speak on what happened, regardless if that's now or later.
Well, then do you want a bench trial or a jury trial?
What does that mean? She told me earlier, but it's my
bench trial is where the judge is the fact finder. A jury trial is where a jury of your peers from Huntington Woods, Pleasant Ridge, Royal Oak Township, Oak Park will decide your guilt or innocence.
So the first one, the judge
is the judge, yes. The second one is the jury. And we
like jury, people do jury duty. You talking about that?
Yes.
I don't know which one is the better option. Where I can.
That's why you often have an attorney to help advise you. That's why we appointed an attorney to help you. Who knows or can advise.
This moment is bigger than it sounds. Bench trial or jury trial isn't a technical detail. It's a strategic decision. And here, he's being asked to choose without understanding the consequences. This is exactly why lawyers exist.
Your Honor, it's
Like,
been explained that he has a right not to testify, which I feel like you've gone into, but you have a right to testify on your own behalf, but you also have a right not to testify. And that is where your words would come out to either the judge or to the jury, okay?
oh, so I can
Sorry.
get
Okay.
I can get a appointed attorney and still choose to testify. Is what you're saying?
Yes.
I didn't know that. I don't know. This is all new to me. It's my first one.
That sentence, "I didn't know that," says everything. This is an arrogance. This is someone walking into a system that speaks a language he doesn't understand, realizing it in real time.
Because at this point, a lot of this stuff that the judge has gone over, we've gone over. But I mean, it's okay because the judge really can't give you legal advice. That's what I'm here for. But a lot of this we've already gone over, sir. So if I am your attorney, you are going to actually have to conversate with me and listen to what I'm saying. Should you feel like my experience is not enough for you, we can ask for another attorney because I know a lot of this we've already talked about. So I mean, it seems like maybe you're not heeding what I've said or what I've said to you doesn't seem to be important because a lot of this that the judge has already gone over, we've already discussed.
I'll just have the judge not have the jury trial, like have the jury make the decision.
Your Honor, I'm gonna say I really don't feel like this is an informed decision for him to make right now. Because I definitely probably would advise for a jury trial, but
why is that?
Your Honor, I would just, you know what? I feel like I've had conversations with this client, and I feel like my expertise is not being heeded. I don't know why, but I feel like this isn't appropriate. This isn't appropriate to have this conversation on the record. He does need an attorney, but I don't know if he's heeding my conversation. So maybe he needs a different.
You almost never hear an attorney say this on the record. She's frustrated, not because she doesn't care, but because she does. She knows he's not hearing her, and she knows the risk. This isn't drama. It's professional alarm bells.
I just made my decision. I want the jury.
But I just thought you said you want the judge. I know you just said the judge.
Judge. That was an accident. Judge. There we go.
Your Honor, I would just ask to be removed from this case because really my client is just, we've had these conversations. He's a bit confused.
Your Honor,
we're going in circles.
Set this for in-person.
Well, how will that change if it's a different attorney, Ms. Blakely?
Maybe he'll respect their opinion more. I don't know.
Why would
we can't? You know what? We can. Well, there are a lot of different reasons that I'd rather not say. We can set it for in person. It's just this. I just feel like right now some of the stuff that he's saying has already been discussed. We've already discussed. We're just going in circles, and I feel like this is.
I spend much of my day like that, Ms. Blakely. It's okay. It's my job.
Okay.
It's 12:30, and I have another docket at 1 o'clock. I agree.
Judge trial. I don't want the jury, and I would like to represent myself. No lawyer. Just feel like that. No attorney. I mean, yeah.
This is what overwhelm looks like. Decisions flip. Words get tangled. One moment it's jury. The next it's judge. Then no attorney at all. From the outside, it might look indecisive, but really, it's cognitive overload.
All right. I am going to set this for a final pretrial. I will request another MIDC advice only so that you can confirm what it is you want to do. And I'm going to reset for final pretrial. July 24th at 1:40. Appoint advice only MIDC. All right, you can make your final decision on the 24th of July. You need to be back here at 1:40 on the 24th. Thank you.
The judge does the only responsible thing here. She slows it down. Another attorney. Another date. Because justice isn't about rushing someone into a bad decision.